Return and rejection of plaint, grounds for rejection, reliefs found to plaintiff after return or rejection of plaint. Please do subscribe the channel and click bell icon to get notifications by Trayvon Law. On what grounds a plaint can be returned? A plaint can be returned by the following provisions, that is, Ord VII RUl 10 Class 1, Return of plaint. This order states that a plaint can be returned by any court if the court that is presented cannot be tried in the filed court due to lack of jurisdiction. Thus, the court may return the plaint for it to be presented in the proper court. That means, return of the plaint will be done by the court when the court does not have the jurisdiction. If the plaintiff files the suit in the particular court which does not have the jurisdiction, then the said court return the plaint by mentioning the reasons for the return. Ord VII RUl 10 Class 2 Procedure to return plaint. While returning the plaint, the court shall mention the following particulars in the plaint, that is, date of return of the plaint, date of presentation of plaint, name of the party presenting the plaint, statements stating the reason for return of the plaint. Ord VII RUl 10A. Power of the court to fix the date of appearance in the required court. After return of the plaint, the court fixes the date for appearance of the parties before the other court where the plaintiff is going to file the suit again. If the defendant has appeared in the court and the court is returning the plaint, the court shall intimate its opinion to the plaintiff. When such an intimation is given to the plaintiff shall, with an application, ask the court to mention the court in which the suit shall be presented after the return. Praying the court to fix a date for the appearance of parties in the said court. Requesting the notice of the date to be given to the defendant also. After receiving the application of the court, shall fix a date for the appearance of the parties in the court where the plaintiff is supposed to be presented. Give the plaintiff and the defendant notice to appear in the court. Means, while it is returning, the court gives the opportunity for both the plaintiff and defendant to appear before the court where the plaintiff is going to file the suit. When the notice of date is given, it is not necessary for the court in which the plaint is returned to issue summons to the defendant, because earlier court, that is the previous court, mentions the date and appearance shall be taken as a summons. So, subsequent court after return where the plaintiff is going and filing the suit again, that court may not give the summons to the defendant because earlier notice will be treated as a summons. After the application is given by the plaintiff on return of suit, the plaintiff cannot then appeal against the court on returning the plaint. Remedies on return of plaint. Plaintiff may file a new suit. Plaintiff may amend the plaint. Plaintiff may file an appeal. Only first appeal can be filed against the order of return. Rejection of plaint. Rule 11 of Ord VII of CPC deals with rejection of plaint. Rule 11 says that plaint will be rejected in the following grounds: where it does not disclose a cause of action. Cause of action is the most important thing for maintainability of the suit, that is plaint. If the plaint filed by the plaintiff does not disclose any cause of action, the court will reject it. But in order to reject the plaint on this ground, the court must look at the plaint and nothing else. Means, when the court is rejecting the plaint on the ground of the cause of action, it has to go through the contents of the plaint and come to the conclusion that there is no case on behalf of the plaintiff. Then only the court can reject on the ground of the cause of action. The power to reject a plaint on this ground should be exercised only if the court comes to the conclusion that even if all the allegations set out in the plaint are proved, the plaintiff would not be entitled to any relief. In that case, the court will reject the plaint without issuing summons to the defendants. The Supreme Court in Arivandanam versus Satyapal held that the reading of the plaint should be meaningful and not formal. Again, the Supreme Court held in Rupal versus Gill that the plaint can be rejected as a whole if it does not disclose cause of action. A part of it cannot be rejected. Locus standi. The basis of filing a suit is locus standi. The term means that one need to show that some legitimate right of the individual has been damaged and such infringement has brought some damages to the individual. If there is no locus standi, then no suit can be brought, as it provides the ground which were abused which led to the institution of the suit. Means locus standi means the person's right should be deprived by the other person. His right should be infringed or damaged. Then the cause of action starts. So the whose right is infringed or damaged, then that persons get the locus standi to file the suit. Next ground for rejection of plaint is where the relief claim is undervalued. Where the relief claimed by the plaintiff is undervalued and the valuation is not corrected within the time fixed or extended by the court, the plaint will be rejected. The Supreme Court in Meenakshi Sundaran versus Venkatachalam held that in the considering of question whether the suit is properly valued or not, the court must confine its attention to the plaint only and should not look at the other circumstances which may subsequently influence the judgment of the court as to the true value of the relief prayed for. Other ground is where it is not insufficiently stamped. Sometimes the relief claimed by the plaintiff is not properly valued, but the plaint is written upon a paper insufficiently stamped and the plaintiff fails to pay the requisite court fee within the time fixed or extended by the court. In the case, the plaint will be rejected. However, if the requisite court fee is paid within the time extended by the court, the suit or appeal must be treated as instituted from the date of presentation of plaint or memorandum of appeal for the purpose of limitation as well as paid of court fee mentioned under section 149 CPC. If the plaintiff cannot pay the court fee, Order 33 provides for continuing the suit as an indigent person. Order 33 says about the indigent person, the person who does not have the capacity to pay the court fee, who declared himself as an indigent. In such cases, exemption will be given for the persons who claim for the as an indigent persons. Rule 12. Procedure on rejection of plaint. Where a plaint is rejected by the court, the judge will pass the order to that effect and will record the reasons for it. Whenever the judge is rejecting the plaint, then he has to particularly mention the reasons on what grounds he is rejecting the plaint. That is mandatory. Rule 13. Effects of rejection of plaint. If the plaint is rejected on any of the above grounds, the plaintiff is not thereby precluded from presenting a fresh plaint in respect of same cause of action. It means if the plaint is rejected by the court on the grounds mentioned in Order 7 Rule 11, then the plaintiff can file the fresh plaint with the same cause of action again. Any order rejecting a plaint is considered as a degree. So, as the rejection of plaint is considered as a degree, the plaintiff can go for the appeal also. If the statements in the plaint shows that the suit is barred by any law, the court will reject the plaint. And the other ground is if the statements of the plaint shows that the contents mentioned in the plaint is barred by any law, then the suit will be rejected. If plaint itself shows the claim is barred by limitation, the plaint will be rejected. If there is a bar of limitation, means limitation period is expired, then also the court reject the plaint. According to Order 4, Rule 1, every suit shall be instituted by presenting a plaint in duplicate. If such a requirement is not fulfilled, then the plaint can be rejected. Non-compliance with statutory provisions. If the plaintiff fails to go according to the provision, the plaint shall be rejected. Other grounds of rejection. If a plaint is signed by a person not authorized by the plaintiff and it is not corrected within the stipulated time, such a plaint can be rejected. Mode of rejection of plaint. The plaint can be rejected by two methods. The plaintiff can file an application at any stage of the suit for rejection of the plaint. The judge can at any stage of the suit reject the plaint if it does not fulfill the requirements and comes under the rule of Order 7 of the CPC. Difference between return and rejection of plaint. Rejection of plaint, jurisdiction of court may be proper, but suit may not comply Rule 11 of CPC. In return of plaint, jurisdiction of trying the suit is absent for the court. The drafting of the plaint may be right. Rejection of plaint can be through application or suo motu. Return of plaint is always suo motu. In case of rejection of plaint, second appeal can be filed. In return of plaint, second appeal is not allowed. Order rejecting plaint amounts to degree. Order returning plaint is not a degree. Revision on rejection of plaint cannot be filed. In returning plaint, revision can be filed. It is not exhausted in nature. It is exhausted in nature.